Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again, and we are back with a new video on your legal Darpan, that is your peek into weekly legal affairs. So this is the episode 3 that we are going to be discussing today. So we have got back our legal affairs, and I hope you all are hitting on the like button, and also don't forget to hit on the share and subscribe button. So if you are new to the channel, do make sure that you are also a part of our Telegram channel on the name CLAT @Pratham. So do make sure that you are looking for all the articles, news updates for the law entrance exams, and you are also taking the expert advices that the mentors are giving you on this channel itself. Now, first thing first is that multi-state cooperative societies amendment bill have been coming up, and the union cabinet has recently approved these changes. Now the first thing is that the amendment bill is coming in 2022. It incorporates 97 constitutional amendments which provides constitutional status to cooperative societies. And in order to realize this goal, they will also seek transparency and accountability in the multi-state corporate societies. Now, to improve these corporate societies, the amendment bill also proposes to establish cooperative election authorities, cooperative information officers, and cooperative ombudsmen also. Now, the cooperative ombudsman will provide a mechanism for the redressal of grievances. Okay, redressal of grievances means that if any cooperative is going through any problems, all their grievances will be redressed by this person. That means that they will be taking care of all the complaints. Now, the cooperative information will increase transparency by providing access to information to members in a timely manner. Now, also, it is to boost to ease of doing business in the sector and also shortening the registration period. It also allows applicants to seek extra time of 2 months to rectify mistakes. Now, the bill proposes the inclusions of co-opt directors with experience in the field of banking, management, cooperative management, and finance. Now, the boost funding of multi-state cooperative society, the bill has provisions for issuance of non-voting shares also. Now, the next news for the day is that Justice D.Y. Chandrachud has been appointed as the 50th Chief Justice of India. Very, very important news for all the law aspirants. So, Justice Dhananjay Yashwant Chandrachud is set to become the 50th Chief Justice of India in November of 2022. Now, the Chief Justice of India, U. Lalit, has nominated Justice D.Y. Chandrachud as his successor during a meeting involving other judges of the Supreme Court of India. Now, the appointment is approved by the central government. Justice D.Y. Chandrachud would be the first second generation Chief Justice of India. Now, D.Y. Chandrachud's father, Justice Y.V. Chandrachud, was the 16th Chief Justice of India. Now, the Justice Y.V. Chandrachud became CJI in 1978. He held this position for the longest tenure of 7 years. His son, Justice D.Y. Chandrachud, has been appointed a Supreme Court Justice for 2 years, the longest in the recent past. Now, Justice Y.V. Chandrachud sentenced Sanjay Gandhi to jail. So his father has been a Chief Justice who has taken some very like big steps in the country, right? Concerning the film Kissa Kursi Ka, right? A political satire film that was banned during the time of national emergency. Now, during his tenure as Supreme Court Judge, D.Y. Chandrachud has overturned 2 judgments made by his father. These cases concern adultery and also the right to privacy. Now, in 2017, the top court involving Justice D.Y. Chandrachud and other judges overruled the 1975 ruling of the infamous habeas corpus case, which allowed the suspension of right to life during emergency. So we have heard about this, and D.Y. Chandrachud was the person who was there in this case. In 1975, the former CJI Chandrachud was among the 5 judges who upheld the precedent order to impose the emergency in the country also. Now, Other landmark judgments involving DY Chandrachud concerns euthanasia, entry of women into Sabrimala, that was the temple. Sabrimala case was very, very famous. Decriminalizing of homosexuality, right? That's also one of the steps that were taken by Justice DY Chandrachud. Abortion rights, the Haidia case, medical college case, and the PIL for mandatorily paying the national anthem in the cinema halls. So there have been a lot of cases that he has given his judgments on, and it is something very, very important that we are seeing him as a role in the Chief Justice of India, which will be taking in a lot of changes, right? We can see there have been a lot of changes currently in the CGIs very, very recently. So these changes are something that we will see in the future also. Now, the adoption of the world's first single charger rule. Now, the European Parliament has approved the new rule to introduce single charging port for electronic gadgets by 2024 in the EU, right? So the new EU law states all the new smartphones, tablets, and camera will have a single standard charger. That means that you don't have to carry different kinds of chargers now. The new rule allows the customers to choose between two chargers, one with and one without USB-C chargers while purchasing a handheld device. That can be a laptop, it can be related to a smartphone, a tablet, it can cover all those things. Now, under the first phase of the law, which will be implemented from late 2024, all mobile phones, tablets, and cameras sold in EU will be equipped with USB-C charging ports. From 2026, the rules will be expanded to include laptops also under the same arena. It is expected to impact smartphone manufacturers such as Apple, since these rules will force changes in the charging ports of iPhones and other devices for the users in the EU, right? So iPhones right now work on a different type of USB, right? These are called iOS devices, so they run differently than the Androids. So they will also have to align their phones according to the expectations of the European markets. Now, the next is that the USB-C ports can charge up to 100 watts, transfer up to 40 GB per second, and link to external devices. Now, in the next 2 years, the EU law will affect all mobile phones, video game consoles, headphones, headsets, tablets, digital cameras, portable speakers, e-readers, that is your Kindle, earbuds, mic, keyboards, and portable navigation system. The new law aims to minimize the e-waste so that the person doesn't have to buy these chargers again and again. It will also simplify the life of Europeans, will save at least 200 million euros per year, and significantly bring down the electronic waste every year. Currently, about 11,000 tons of e-waste is generated. Will also put an end to the technological lock-in effect, which involves a consumer fully depending on a single manufacturer. While these rules may adversely affect the businesses in the short run, but it will also promote the new sales of improved version of gadgets, improving profits for tech companies such as Apple, Samsung, and Huawei, right? So these are very, very important changes that have been taken up by the European Union. The Supreme Court's order on legal abortion. So this was right now a lot in news. So all the people who have been watching the news recently would have found out this entire news on the channel also, and we are discussing it today itself. That the Supreme Court recently held that women, regardless of their marital status, that means that if they are married, they are unmarried, whatever they are entitled to safe and legal abortion until 24 weeks of pregnancy, right? So that's what they have said. Now, the apex court also held that the differentiation between an unmarried or a married woman under abortion law was artificial and was constitutionally unsustainable, right? So it is unsustainable constitutionally also, that because a woman has the right to choose what she has to do with her body. Now, it held that abortion for unmarried and single women whose pregnancies are between the time of 20 to 24 weeks cannot be denied, right? Now, the MTP Act of 1971 does allow does not allow abortion for unmarried pregnant women between 20 to 24 weeks after consensual sexual activity. Now, the court held that the Rule 3B of the MTP Act is unconstitutional since it deprives the unmarried women the right to access safe and legal abortions after 20 weeks, like if they face in the maternal circumstances similar to a married women, right? So it was said that it is an unconstitutional act that is there. There's an unconstitutional rule that is surviving in the MTP Act. Now, the Rule 3B gives only rape survivors, minors, women whose marital status changed during pregnancy, mentally ill women, or women with fetal malformation has the right to abortion. Now it has been extended to the unmarried women also. So that's a great step that is being taken by the Supreme Court of India very, very recently. Now, if the pregnancy involved consensual sex, the termination is allowed until 20 weeks. The distinction was held by Supreme Court as a violation of right to equality, right? The bench held that the right of reproductive autonomy, dignity, and privacy is provided under Article 21 of the Constitution. Now, this provides unmarried women the right to choose whether or not to bear a child just as a married women, right? So it's giving an equality to both married and unmarried women, and they have their choice to choose, do they want to carry the child or not. It's their choice entirely. Now, coming to the next part, the judgment is significant as it is a first ever legal recognition of marital rape, although within the limited purview of abortion. Now, the Supreme Court also held that meaning of rape should also include marital rape solely for the purpose of MTP Act and related rules, as they don't want to change anything in the Marriages Act that are existing there. They just want to take into consideration it under the MTP Act only, that is the that is related to abortion itself. Now, the MTP Act also allows legal abortion in two stages. Okay, termination of pregnancy is allowed up to 20 weeks under the opinion of registered medical practitioner. For pregnancies between 20 to 24, the law provides certain criteria to avail termination. It requires opinion or two registered medical practitioners to take a call on such a case, right? So that's what the MTP Act certainly talks about. Now, next is N. Venkataramani is the new Attorney General of India. He is a senior advocate in the Supreme Court and has been appointed as the Attorney General of India for a period of 3 years. He has a varied experience of 42 years in practicing in the Apex Court of India, enrolled with the Bar Council of Tamil Nadu, and also joined the chambers of P.P. Rao, senior advocate of Supreme Court in 1979. Now, he practiced in various branches of law like constitutional law, law of indirect taxes, human rights, civil and criminal consumer law, and laws related to services. Now, he was invited at the workshop jointly organized by the United Nations Commission for Human Rights and International Commission for Jurists at Geneva in 2001. The workshop sought to submit reports to the Human Rights Commissions on the optional protocol to the International Convention on Economic, Social, and Cultural Rights. That is also called the ICESR-SCR, that was established in 1966. Now, senior advocate Venkataramani was also involved in the activities of international courts of justice in the Afro-Asian region, especially those concerning to ICESCR. Now, he became a member of the Law Committee in 2010 and also again another term in 2013. Now, he is set to succeed K.K. Venugopal as the Attorney General of India. Now, the Attorney General of India is appointed by the President of India under Article 76 of the Indian Constitution. Very, very important for you. He is the highest law officer of India. Attorney General of India must be eligible for becoming a Supreme Court judge. Then only he can become an Attorney General. There is no specific tenure for an Attorney General, and he holds the office during the pleasure of the President of India. Till the President of India allows them to hold the position, they will hold the position there. Now, the Constitution also does not specify the grounds or the procedures for their dismissals, and also he can be removed by the president at any given point of time. So that's why it is said that they are holding the position and during the pleasure of the President of India. That's why that term is being used, right? So that's it for today, guys. Thanks for joining this live session. Do make sure that you hit on the like, share, and subscribe button before you go. And also don't forget to share it to your friends. And do make sure that you are visiting our page very, very regularly on Instagram, and also making sure that you are reading all the news that are being uploaded there. So thank you for being a lovely audience. Do take care of yourself and have a nice day ahead.